Get ready. 3 seconds. 2 seconds. Start. A joint petition for dissolution of the marriage by mutual consent was moved by the petitioner and the respondent on 10/8/1983. On 4/9/1984, the husband alone filed the petition under Section 13B (2) of the Act. The wife did not join the proceedings, or in other words, did not consent for the second motion to be met under the said subsection. The learned ADJ dismissed the petition filed by the husband, holding that if one of the parties withheld the consent, a decree for divorce cannot be granted under the said subsection. On the facts of the case, the learned judge also opined that there was every likelihood that the wife had joined the petition under Section 13B (1) without her free consent. The learned judge has disagreed with the two decisions cited before him. They are Jayashree Lodha versus Ramesh Lodha, 1984, DMC 481, and Meena Datta versus Aniruddha Datta, Roman 2, 1984, DMC 388. These decisions are of the other high courts, and there is no decision for this court on this question. For passing a decree of divorce under subsection 2 of the motion has met to be met by both the parties under subclause 2. It is so because the court must be satisfied that the dissolution of marriage is mutually agreed by the parties, and the agreement continues till the passing of the decree. It is difficult to reconcile the judgment of the Bombay High Court and Madhya Pradesh High Court with this requirement of subclause 2, because in those cases the divorce by mutual consent was ordered by the High Court on a motion made by one of the parties. The special duties of the matrimonial court under Section 23 of the Act are equally applicable to the proceedings under Section 13B of the Act, as Section 13B is to be made applicable subject to other provisions of the Act. Under subsection 23 (1) it is the duty of the matrimonial court to see that the petitioner is not in any way taking advantage of his or her own wrong or disability for the purpose of such relief. The Madhya Pradesh case and Bombay case referred to above show that the husband were trying to take advantage of their own wrong by refusing to give a fixed deposit of rupees 20,000 to the wife, and by frivolous plea of confusion in the mind, respectively. Since the petition under Section 13B (1) is a joint petition, both the parties are petitioners. The matrimonial court therefore has a duty to deny the fruit of avoiding a decree to a party which was committed wrong. The court can, in such a circumstances, hold that the agreement to have the dissolution continues to abide and pass a decree under Section 13B of the Act. The respondent wife had averred that the first petition under Section 13B Roman 1 was dismissed because the father of the husband slapped her father in the court. It only means that because of the alleged incident, she made a statement before the additional district and session judge that her consent was not a free consent. The husband had denied this allegation. But even assuming that the allegation is correct, it was totally irrelevant ground for her to withdraw her consent and to allege that even the filing of the application at the earliest stage was obtained by force, fraud, etc. I have no hesitation in holding that the wife at her own free will had signed both the petition and had given voluntary consent for the dissolution of marriage under section 1b of the Act. I therefore pass a decree of the dissolution of marriage under section 13b of the Hindu Marriage Act and declare that the marriage between the appellant and the respondent stands dissolved under the said section. So far as the payment of rupees 11,000 agreed to be paid by the husband to the wife is concerned, there is no clear evidence of the actual payment received by the wife. If this is so, the appellant husband shall make a payment of rupees 11,000 to the wife within 3 months from today in full and final settlement of all the claims of the wife, including the one for permanent alimony, as agreed between the parties by agreement. Stop.